Greetings of the day. I am Dr. Latha from the Postgraduate Program in Human Resource Management, M.O.P. Vaishnav College for Women. Welcome to the first module on the course Labour Legislation. Whether you plan to be an employee or an employer someday, knowing the existing laws in India helps you to protect the rights and promote the welfare, fairness of the employees at the workplace. In today's module, you will be learning what labour laws are, why they matter, and how they help to protect and promote the fairness at the workplace. Labour legislation, we can split the term into two, labour and legislations. Labour or workers have to be administered. Administering labour is a very big responsibility because any change in the social or economic evil will reflect in the labour market. Hence, the labour has to be administered. Here comes the role of labour legislation. Legislation is a law or laws passed by the government. Any enlightened state would intervene in the context of industry and impose statutory obligations mostly on the employer and to a lesser degree on the employee in order to maintain working conditions, a minimum wage, safe working environment, providing compensation in case of accidents, medical facilities for the future, etc. With this broad description, let us now define labour law. The term labour legislations or labour law is used to denote that body of laws which deals with employment and non-employment of wages, working conditions, industrial relations, social security and labour welfare of industrially employed persons. Let us now discuss the need for labour legislations. The need for labour legislations is discussed based on two basic concepts: to maintain the good relationship between employee and employer and to promote the well-being of employees. Keeping in mind these aspects, the need for labour legislation is summarized as follows. Individual workers are economically weak. They cannot bargain themselves to protect their rights with the employees. Hence, legislations are required to protect them from long working hours, unsafe hygienic conditions, and a minimum wage and exploitation of workers. Legislations are required because the workers are exposed to certain risk in factories, mines and establishments. The labour legislations is required to enhance the power of bargaining of the workers by means of encouraging the formation of trade union. The legislation is also required to protect the children and women who are being taken to work in hazardous conditions and at odd hours. Legislation is also required to pay the compensation to workers who die or injured during and at the time of work. Legislation is required. So, the labour plays a very vital role in enhancing the productivity for the organization. Hence, it is very important for the management to create a situation where the labourers can contribute their maximum to achieve these objectives. To understand the need for labour legislations, I have given just a mini case study, that is the gig workers, Ola and Uber driver. Recently, they have raised concern about their working conditions. Also, these drivers are labelled as partners. Many argue they should be treated as employee because they work for long hours, they are dependent on the platform for income and their earnings are often controlled by the algorithm. The main issue under this case is that the drivers, they do not receive employee benefits like PF, medical insurance, paid leaves and fixed working hours. So, the drivers and worker union have taken this issue to the court and have demanded protection under labour laws. The governments and Supreme Court have begun to consider bringing gig and platform workers under the protection of labour codes, particularly under the Social Security Code 2020. Let us move on to the objectives of labour relations. When you talk about the objectives, it is twofold. Number one is to preserve the health, safety and welfare of workers, and number 2 is to maintain good relations between employers and employees. As I told already, labor plays a vital role in enhancing the productivity of the organization. Hence, it is the primary responsibility of the management to provide such kind of situations for the laborers to exhibit their maximum contribution for achieving this particular objectives. Let us move on to the principles of labor legislations. The fundamental principles of labor legislations are social justice, social equity, international uniformity and national economy. Coming to social justice, in modern industrial setup, the workers are finding it very difficult to protect their interest by themselves. Hence, the state has to intervene by helping them by means of granting freedom of association, power of collective bargaining and by means of helping them by providing mediation and arbitration in the case of industrial conflicts. The example of legislations for these principles are Workman Compensation Act, Minimum Wages Act, etc. Coming to social equity, it is setting equitable legislations for all by means of obligations to do so. Coming to the principle of international uniformity, ILO plays a very important role. They have produced a good record by means of conducting international conventions and recommendations. They have provided the data on the long hours, working conditions, young persons, women, children, hazardous conditions, etc. Next, moving on to the national economy, the legislations, it is very, very important to consider the economy of the state. Yes. So far we have discussed about the introduction, need for studying the labor law, objectives and principles on which the labor law is been revolving around. Next, we move on to the classification of labor legislations. When you talk about the classification, the labor legislations have been classified into 4 categories. One is regulative labor legislations, number 2 is protective labor legislations, wage related labor legislations and labor welfare and social security. Coming to this regulative measures, the legislation's objective is to focus on maintaining good relations between employer and employer and also to produce methods and manners for avoiding industrial conflicts. The examples of regulative measures are Trade Union Act 1926, Industrial Dispute Act 1947 and Industrial Employment Act 1946. Coming to the protective measures, the legislations which are used to protect the labor standards and working conditions. The example of protective labor legislations are Factories Act 1948, Mines Act 1952, Shops and Establishments Act passed by various states and Plantation Labor Act 1951. These acts will focus on working conditions, labor hours, health, safety and welfare measures. Coming to the wage related labor legislations, the laws which are discussing about the methods and matters of wage payment are discussed under wage related legislations. The example of wage related measures are Payment of Wages Act 1936, Minimum Wages Act 1948, Equal Remuneration Act 1976 and Payment of Bonus Act 1965. Coming to the last category of social security, under this category all the legislations which are indented to provide the social security benefits to the workers when they have some kind of contingencies in life at work. Examples, Workman Compensation Act 1923, Payment of Gratuity Act 1972 and Maternity Benefit Act 1961 and the Employee State Insurance Act 1948. In today's discussion, we have studied the introduction and need for labor legislation, examined their key objectives, reviewed certain fundamental principles of labor legislations and also have studied how these acts help to improve the industrial relations. To conclude, labor laws are dynamic and they evolve in response to economic, social and technological changes. Example, gig economy and remote work. Understanding these laws are very much necessary for the professionals in HR, management, legal compliances and public administration. For more such informative videos, like, share and subscribe to M.O.P Classroom. Thank you.